Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone, the wait is finally over. The Pension Scheme Act 2021 became law on the 11th of February. The hotly debated Act introduces some significant changes to the pensions landscape, although I would note that most of the Act is not yet in force and will not be for some time. In this episode, I'm going to canter through some of the key changes which will be introduced by the Act. There is quite a bit to get through, so let's get started. The first change I'm going to talk about is the introduction of the legislative framework for collective money purchase schemes. The Act includes provisions about their establishment and administration, as well as their authorisation and supervision by the pensions regulator. Just by way of a little background, collective money purchase schemes provide employers with certainty because, under a collective money purchase scheme, employers as well as members pay a fixed contribution rate. The benefit for members is that the assets are all pooled, which means savers share the investment and longevity risks. Members are promised a target as opposed to guaranteed pension on retirement. So on the one hand, the pension can be reduced if investment returns are poor, and on the other hand, annual increases and revaluation rates vary according to the investment returns. In order to be authorised by the regulator as a collective money purchase scheme, a scheme will have to meet certain criteria, including that the scheme must be financially sustainable and have adequate systems and processes for communicating with members and others, and the persons involved in the scheme must be fit and proper persons. It remains to be seen how collective money purchase schemes will work in practice, but it is expected that they will be very similar to DC Master Trusts, except a collective money purchase scheme can only be used by a single employer or two or more connected employers. One point that is clear is that collective money purchase schemes will be classed as providing money purchase benefits, which means that employers will not be required to make good any funding shortfall. I will move on to the long-discussed pensions dashboard now. The pensions dashboard is a single digital view where every member can clearly see in one place all of their pension savings. The Act introduces the framework for the long-anticipated pensions dashboard. The details will be set out in regulations, but will include how the pensions dashboard will be established, administered, and what information will actually be included. The requirement to provide information to qualifying pension dashboard will fall on trustees, but from a practical perspective, trustees and employers are likely to have to work very closely together to provide the information required for the pensions dashboard. Another area that the Act impacts is statutory transfers. Now, it's long been recognised that sometimes trustees are in a difficult position because, at the end of the day, if a member has a right to a statutory transfer, it has to be paid. The Act shifts the position slightly, as now trustees will be prevented from making a statutory transfer unless certain conditions are met. The detail of the conditions will be set out in regulations, but it is clear that there will be restrictions relating to the member's employment or place of residence, and that the member will be required to provide evidence of certain information or guidance. I'm going to talk now about the framework that the Act introduces in respect of governance and reporting requirements for climate-related risks. Again, the detail will be set out in regulations and statutory guidance, although I am pleased to report that these draft regulations have already been published for consultation. The key points to note are that trustees will be subject to new requirements to ensure that they have in place effective governance in respect of the effects of climate change. Trustees will also have to report certain information, such as an annual climate risk disclosure report, which addresses the scheme's performance against the government's requirements. Turning to funding now, the Act will require trustees of defined benefit pension schemes to produce a funding and investment strategy, which will have to set out the funding levels that the trustees intend the scheme to achieve by a particular date and how this will be achieved. Trustees will, as soon as reasonably practical after determining or reviewing a fund and investment strategy, have to produce a written statement setting out the detail. Regulations on this new requirement are expected shortly and will include what such a written statement is to cover. What is already known is that the trustees will have to seek employer consent to such a statement. I'm going to spend the rest of this episode talking about the new regulator powers. So to start with, the Act introduces some new criminal offences, being 1. Avoidance of a statutory Section 75 employer debt. 2. Conduct risking accrued scheme benefits. And 3. Failure to comply with a contribution notice. So I'm going to cover each of these in turn. So starting with the avoidance of a statutory Section 75 employer debt. This offence applies to any person who acts or fails to act with the intention of preventing the recovery of the whole or part of a Section 75 debt, preventing such a debt becoming due or compromising the debt. There is a defence to this criminal offence of reasonable excuse, although what is meant by reasonable excuse is not yet clear because it's not defined in the Act, but it is expected that the regulator will issue guidance on the new criminal offences and this reasonable excuse defence in due course. There were lots of concerns raised about this offence, including in light of the fact that it applies to any person. This means that it could capture routine corporate activities by parties involved with pension schemes, as well as those not directly involved with a pension scheme. This means that, as you would expect, trustees could be caught, but it's also possible that other parties, such as a bank lending to a sponsoring employer, insurers, or a company wanting to buy a company with a DB pension scheme, could be caught if there is a DB pension scheme supported by an employer in the corporate group. It is also true that advisors to a company with a DB pension scheme or trustees could be caught, although there is a specific carve-out for insolvency practitioners. If a person is found guilty of this criminal offence, he or she can be imprisoned for up to 7 years and/or have an unlimited fine imposed on them. This is in addition to the regulator's ability to oppose a civil penalty, which under the Act can be up to £1 million. There were requests as the Act was passing through Parliament to limit the drafting of the Act, as there were fears that the criminal offences could undermine the UK's rescue culture. But these were rejected on the basis that it's important that where the elements of an offence are met, the responsible person should be punished no matter who has committed the offence. It was also emphasised that it is for the regulator to prove that an excuse is not reasonable, i.e., it will be presumed that a person has a reasonable excuse for taking an action or failing to act unless proved otherwise. I would also make the point that in reality, the regulator is likely to only use the new criminal powers where somebody does something which is so clearly criminal, as opposed to reasonable people doing their best but technically falling foul of the law. I think it's much more likely that the regulator will use its powers to issue a civil penalty. Moving on to the conduct risking accrued scheme benefits criminal offence, just rolls off the tongue. This applies where a person acts in a way which detrimentally affects, in a material way, the likelihood of accrued scheme benefits being received provided the person knew, or ought to have known, that the act would have that effect. This goes beyond recklessness. Again, as with the avoidance of a statutory employer debt offence, there is a reasonable excuse defence, and the offence is drafted very widely so it can apply to any person, including, for example, any decision maker in a company which has a company in the same corporate group with a DB pension scheme, although, again, insolvency practitioners are carved out of this catch-all. Also, similarly to the previous offence, a person can be liable on conviction to an unlimited fine and/or prison for up to 7 years, which is in addition to the regulator's ability to impose a civil penalty of up to $1 million. The final criminal offence I'm going to talk about is the failure to comply with a contribution notice. It is important to note that, as well as introducing this new criminal offence, the Act also widens the grounds for imposing a contribution notice. The Act adds 2 new grounds which make it easier for the regulator to issue a contribution notice. Very broadly, the Act introduces 1. The employer insolvency test. This allows a contribution notice to be issued where, immediately after an act or failure to act, if the employer was to suffer a hypothetical insolvency event and trigger a statutory 75 debt, and the regulator is of the opinion that the act or failure to act materially reduces the amount of the Section 75 debt which the scheme could recover. And 2, the employer resources test. This allows a contribution notice to be issued where the regulator is of the view that an act or failure to act would have reduced the value of the employer's resources, and this reduction is material relative to the estimated Section 75 debt in relation to the scheme. Whilst the Act widens the grounds for imposing a contribution notice, it is important to remember that the regulator must still establish that it is reasonable to impose a contribution notice. There is also a statutory defence to both these new grounds, where a person gave due consideration to the act or failure to act and took all reasonable steps to eliminate or minimise the potential for the act or failure to act to have that impact. The final point I would make about stronger regulator powers is that the Act broadens the scope of the current notifiable events regime. The notifiable events regime will be extended to require the appropriate person, i.e. the sponsoring employer or associated employer, to give notice to the regulator of A. Any notifiable event as soon as reasonably practicable after the relevant person becomes aware of it, the relevant person here being the person given the notice. B. Of any material change in a notifiable event or in the expected effects of a notifiable event. Again, this is to be given as soon as reasonably practicable after the relevant individual becomes aware of the material change, and the details will be set out in regulation. And C. If a notifiable event is not going to or does not take place as soon as reasonably practicable after the person given notice becomes aware of the material change. Again, having this extra layer of consideration in the corporate decision-making process is likely to have an impact on how companies with DB pension schemes behave. I think it's fair to say that the Act makes some significant changes to the pensions landscape. How far all these changes will go in reality remains to be seen, but we should know more shortly when the accompanying regulations and the regulator guidance is published. So for now, I would say watch this space. Thank you for listening. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.